Hello and welcome back to my channel Code Say, and today I am once again back before you with another subject dealing on the legal aspect. Today I shall be dealing with the period of limitation and the certified copy in filing of appeal under section 61 of the IBC. In a recent ruling of Yanklat Principal Bench in the matter of Chandrapati versus Sony Realtors Private Limited. Citation is 2024 IBC Lot 126 Yanklat. The Yanklat, while hearing this appeal concerning the limitation point of view and the certified copy, referred the judgment in the matter of V. Nagarjan versus SKS Ispat and Power Limited and others. Then Sanket Kumar Agarwal and another versus APG Logistics, which is Supreme Court judgment concerning the e-filing. When you do e-filing, on the date of e-filing, your limitation will be concluded. I'll come back to this issue later on. Then Jindal Power Limited versus Dushyant C. Dave, liquidator of Shirpur Power Private Limited and others company appeal 1 of 2023. And then Gaurav Agarwal versus CA Divang P. Sampath, liquidator of MAA Mahamaya Steels Private Limited. The ratio in all put together is as under concerning the limitation and the application of certified copy and running of the limitation and cessation of the limitation. This is all cumulative 9-point ratio. The ratio number 1, the period of limitation is to be renocked from the date of the pronouncement of the order in the cases covered by the code. The code means IBC code. Second, it is mandatory to annex the certified copy of the impugned order with the memorandum of appeal. It is obviously mandatory in all form of the memorandum of appeal where you are challenging the impugned order or a judgment. You need to submit the certified copy of the order under challenge. This is in all form of the appeal, nothing new about that. Needless, that's the one of the ratio. Then the tribunal may exempt the parties from compliance with the procedural requirement in the interest of substantial justice as reiterated in Rule 14. Rule 14 speaks about the NCLT practice rule, which gives a power, an inherent power to exempt from compliance of the certain rule in the interest of justice, obviously. So, and that has been taken care as a ratio in delivering this judgment on the delay condonation. And then there is no automatic exemption where the litigant makes no effort to pursue a timely resolution of their grievances, meaning thereby, in short, a lethargic or laid back litigant is not welcome to who is not interested in pursuing his own remedy in time bound manner cannot expect a court to come to his rescue. Then another point of ratio is appellant having failed to apply for a certified copy rendered the appeal filed before the NCLAT as clearly barred by limitation. When you don't file or don't apply for a certified copy of an impugned judgment and order which you intend to challenge, then obviously and the filing of the appeal is prevented. You can't seek a delay condonation if you are not filing a certified copy and haven't even applied for the certified copy. In that event, the court will not come to your rescue and condone the delay, and it should not be, frankly speaking. Then it is not open to the person aggrieved under the code to await the receipt of the free certified copy under 423 of the Act, which is an IBC Act, read with the Rule 50, which is the NCLT rule, practice rule, and prevent limitation from running. You see, in many statutes, like in criminal proceedings, accused or complainant are entitled for the free copy of the certified copy of the judgment or order. Similarly, in in other special act, special statute, there is a provision for receiving the free certified copy of the order or the judgment which you intend to challenge. Identical provision is there in the IBC Act as well, read with the rule of the NCLT. However, you just can't keep yourself laid back and wait for a free copy to be received without making an effort. In the interest of your own, you should go and apply for the certified copy immediately rather than waiting for the free copy, so that you avoid any kind of delay, which eventually is, if it is with a sufficient ground, court will obviously condone the delay. But if it is not and found at the laid back and lethargic attitude, then obviously court will not come to your rescue. So don't wait for the free copy. Anyways, you should not wait for anything which is free of cost. Then another point number 7, litigant has to file appeal within 30 days, which can be extended up to period of 15 days on showing sufficient cause, which cannot be condoned thereafter. Now, like in commercial suit and arbitration proceeding, there is or other filing of the return statement, there is a specific time bound limitation which can be only extended to another fixed period. Beyond that, nobody can condone, even the courts can't condone. Similarly, in NCLAT appeal, you have to file an appeal within 30 days from the receipt of the certified copy, and another 15 days is additional, which if you eventually file beyond 30 days, but in another 15 days, if you are filing with a sufficient reason that what prevented you from filing the appeal, then it can be condoned. In short, there is a total 45 days which are available to you for filing an appeal. Then, like in when you challenge an arbitration award, the award has to be challenged within a specific time, and further extension is only 30 days. So beyond 120 days, the court are powerless to even condone those delays. So the similar analogy is applied over here. Limitation ceases to run from the date of e-filing. This is pertaining to that Sanket Kumar Agarwal judgment, where the Supreme Court concluded that the moment you do your e-filing, your limitation is completed. Like for an analogy, if I give an example, if suppose tomorrow is the date, that is 8th of March, your limitation is expiring, and you are filing today night by e-filing, that means that your appeal is within the limitation, and the e-filing date will be included. Some people had an confusion whether the physical filing is a date which should be included in the period of limitation, but here the Supreme Court clarified that the date of e-filing is to be included in the computation of the limitation. In order to take advantage of section 12(2) of the Act, which is the Limitation Act, to apply the certified copy has to be applied during the currency of the period. Like, you can't apply, suppose a period of filing limitation of appeal expires on within 30 days, and the judgment is pronounced today on 7th of March. So at the most you can file appeal by 6th of April, subject to the condition that you apply for the certified copy tomorrow. But if you apply the certified copy on the 7th of April, you can't expect that 30 days of your lacuna in applying the certified copy will be included for delay condonation. That is what the false presumption, and it should be avoided. So in all, this was rather a basic, but delay and condonation of the delay is such a technical and mechanical and mathematical proposition that there are a lot of confusions as always. So the NCLAT has tried to clarify those mathematical computation, strict rule of mathematical computation, subject to the condition the litigant is diligent. You apply the certified copy immediately, forthwith. You file an appeal within the prescribed period of time with an extension of 15 days, subject to the condition that you give a sufficient cause of filing the appeal not within the 30 days. So this is all sum and substance of this judgment. The judgment as such has been nicely worded, referring to various judgment and the rules and the sections of the Limitation Act. In fact, there is a provision of Section 14 of the Limitation Act which gives an exemption when you pursue a wrong remedy before the wrong court. Like in cases where you have to file some suits or some other proceeding, but rather you went ahead and filed some other proceeding before some other tribunal which was not maintainable. So those wrongful legal remedy which you availed under the wrongful assumption which killed your limitation is exempted. Those days are exempted under Section 14 if you invoke Section 14 of the Limitation Act. That is an additional point which I am trying to pick it up and give it to you for your understanding. And the judgment considers Section 61 of the IBC code read with the rules, Section 22 Rule 22 subsection 2, more precisely in the matter of V. Nagarajan. So in all, in nutshell, referring to this Supreme Court judgment, the limitation stops running on the e-filing of the appeal and not from the date of presentation of the physical copy. The date on which the order is pronounced is to be excluded from the calculation of the limitation. The time taken by the NCLAT to provide the certified copy would be excluded in calculating the limitation, provided and the appellant apply for the certified copy within the prescribed period under Section 61(2) of the code. This is the conclusion of this judgment. So there were umpteen number of appeal which were beyond limitation, whose delays has been condoned by this common order, referring to those appeal number and all in the body of the judgment. I thought of sharing this recent judgment pronounced on 1st of March by the NCLAT principal bench, Delhi. The quorum was of obviously the chairperson himself with the Justice Rakesh Kumar Jain, the judicial member, and the Naresh Salecha, the technical member. Judgment was in-depth consideration of all the limitation issues concerning and the calculation as well as exemption. The matter was argued by the appellant. There were a lot of senior counsels who appeared. For the respondents, Sumesh Dhawan appeared, and that is how it is. Thank you very much for watching this, and I shall come back to you again once more with some other subject dealing with the legal or law. I hope you like this video, and I request you to keep watching my videos and seek your blessing and support. Thank you very much. Have a nice day.